Let me now discuss mergers and consolidations. The law on mergers and consolidations is found in section 75 all the way up to section 79 of the revised corporation code provides as follows. We initially have to determine what is a merger and what is a consolidation. A merger refers to the absorption by one corporation by another. So if, for example, you have Corporation A and Corporation B, and they agree to merge, then you would have a situation where only either Corporation A or Corporation B will remain. So let us say that on account of the merger, only Corporation A remains. So the situation now would be A and B are the constituent corporations or the party to the merger, and after the merger takes place where A corporation remains, so it would now be the surviving corporation in a merger. If it were a consolidation, it is a combination of two or more corporations to form a new corporation. Using the same examples of Corporation A and Corporation B, when there is a consolidation, there will now be a new corporation, C corporation. A and B in a consolidation are considered the constituent corporations, and after the consolidation where a new corporation is formed, C corporation in our illustration will now be known as the consolidated corporation. So how can a merger or consolidation take place? Under Section 75, there is need initially for the execution and approval of a plan of merger or a plan of consolidation. This plan of merger or consolidation is to be executed individually. So if we go back to our example, Corporation A and Corporation B should each execute a plan of merger or consolidation, which would now set forth the names of the corporation proposing to merge or consolidate, the terms of the merger or consolidation and the manner by which it is to be carried into effect, the statement of changes, if any, in the articles of the surviving corporation in case of a merger, or articles of incorporation in case of a consolidation, and such other provisions that may be deemed necessary or desirable. So after the plan of merger or consolidation is executed, it will now be subject to approval. The requirements of approval are found in Section 76. So each board or the boards of the constituent corporations must approve the plan of merger or consolidation by a majority vote of the board. After a majority vote of the board has been obtained, there will now be a notice that is given to the stockholders or members of the merging corporations, at which time during the meeting that is called for purposes of submitting the plan of merger or consolidation, there is need for an affirmative vote of 2/3 of the outstanding capital stock or of the members of both corporations. A dissenting stockholder given the right of appraisal. So, assuming that these plans of merger or consolidation have been approved by the required number of votes, what will subsequently happen is that there will now be articles of merger or consolidation that would be executed by each of the constituent corporations, signed by the President or Vice President, certified by the Corporate Secretary or Assistant Corporate Secretary, stating the plan of merger. In stock corporation, the number of shares outstanding, and in non-stock corporations, the number of members. In each corporation, the number of shares or members voting for or against the plan of merger or consolidation, the carrying amounts and fair value of the assets and liabilities of the respective companies as of the agreed cutoff date, the method to be used in the merger or consolidation of accounts of both companies, the provisional or pro forma values as merged or consolidated, using the stated accounting method, and such other information as may be prescribed by the Securities and Exchange Commission. Once these articles of merger or consolidation have been jointly prepared, they will now be submitted to the Securities and Exchange Commission. Under Section 78, it is to be submitted to the SEC for its approval. However, in case of mergers or consolidation of banks, banking institutions, loan associations, trust companies, insurance companies, public utilities, educational corporations, and other special corporations governed by special laws, they must have a favorable recommendation coming from the appropriate government regulating agency. Assuming that there are no issues with the submitted articles of merger or consolidation, and if required, there is the favorable recommendation, what will happen is the SEC will now issue a certificate of merger or consolidation. Once the certificate of merger or consolidation is issued, then that would now mean that the merger or consolidation is now effective. On the other hand, if the SEC has reason to believe that the proposed merger or consolidation is contrary to or inconsistent with the provisions of the Corporation Code or existing laws, it will set a hearing to give the corporations concerned the opportunity to be heard. Written notice of the date, time, and place of the hearing shall be given to each of the constituent corporations at least 2 weeks before the hearing. Then the the SEC shall then proceed as provided for in the code and make a determination whether or not there is compliance with the requirements of the law. One possible A requirement that may also be or would be required to be complied with would be what is found in the Philippine Competition Act and circulars issued by the Philippine Competition Commission, because this body is tasked with reviewing mergers and acquisitions. And if in two instances, first, the value of the assets or revenues of the ultimate parent entity of at least one of the parties is at least 6 billion, and if the value of the assets or revenues of the acquired entity is at least 2.4 billion, then that is a merger that would require notification to the Philippine Competition Commission so that it will now subject it to review to determine whether or not it is anti-competitive. So in this particular situation, assuming it is applicable, the SEC action on the issuance of a certificate of merger or consolidation will be put on hold until the Philippine Competition Commission has given its approval to the proposed merger or acquisition. It must be noted, though, that these thresholds, as I have enumerated and stated, will eventually be on hold for the time being with the passage of the Bayanihan II law, which has increased the thresholds now to 50 billion, at least for the next 2 years. Assuming that the constituent corporations are able to hurdle all requirements for the approval of a merger or consolidation, what now are the effects of the merger or consolidation? The effects are found in Section 79 of the law. First, the constituent corporation shall become a single corporation in case of a merger, which shall be designated, as mentioned earlier, as the surviving corporation. And in case of a consolidation, the constituent corporations will transform itself into a new corporation, which shall be called the consolidated corporation. The second effect is the separate existence of the constituent corporations shall cease, except that of the surviving or the consolidated corporation. While it is true that a merger or consolidation causes a dissolution, there will be no need for the affected corporations to undertake the process of dissolution, because one of the consequences of a merger or a consolidation is the acquisition by the surviving or consolidated corporation of all rights, privileges, powers, and liabilities of the absorbed corporation. The third effect is that the surviving or consolidated corporation shall possess all the rights, privileges, and immunities and powers, and shall be subject to all the duties and liabilities of a corporation organized under the Code. Fourth, the surviving or consolidated corporation shall possess all rights, privileges, immunities, and franchises of each constituent corporation, and all real or personal property, all receivables due on whatever account, including subscription to shares and other choices in action, and every other interest of, belonging to, or due to each constituent corporation, shall be deemed transferred to and vested in such surviving or consolidated corporation without further act or deed. To simplify, all assets of whatever nature shall be transferred to the surviving or consolidated corporation without need for any further act or the execution of any deed. And the fifth effect of a consolidation or a merger is that the surviving or consolidated corporation shall be responsible for all the liabilities and obligations of each constituent corporation as though such surviving or consolidated corporation had itself incurred such liabilities or obligations. And any pending claim, action, or proceeding brought by or against any constituent corporation may be prosecuted by or against the surviving or consolidated corporation. The rights of creditors or liens upon property of such constituent corporations will not be impaired by the merger or the consolidation. So, in effect, among the two important things that you need to remember would be the transfer of assets and likewise the transfer of all liabilities to the surviving or the consolidated corporation. This takes place upon issuance of the certificate of merger or consolidation. Previously, or in bar examinations, a question was raised regarding the right of a surviving corporation to enforce a contract entered into by the absorbed corporation after the date of the merger, but prior to the issuance of a certificate of merger. So the situation was, there was a decision as to a merger, but still no certificate of merger. So what happened was in the interim between the decision to merge and the issuance of a certificate of merger, a contract was entered into by one of the constituent corporations. Subsequently, there was now a merger and you now have the surviving corporation. And the surviving corporation is not the corporation that entered into the contract. So the issue now is, would the surviving corporation be entitled to enforce this contract? In the case of Associated Bank versus the Court of Appeals, it was held that since the merger agreement contains a stipulation that all references to the absorbed corporation shall be deemed a reference to the surviving corporation can enforce the contract. Another issue that affects mergers or consolidations would be employees. Are they likewise supposed to be assumed by the surviving corporation? In the absence of any agreement between the constituent corporations, what would happen is that employees of the dissolved corporation will be absorbed by the surviving corporation or the consolidated corporation. What about their respective tenures? Their respective tenures shall continue. So, for example, Corporation A and Corporation B agree to merge, and you have employee X who has been with Corporation A for 10 years, will he now be an employee of Corporation B if it is the surviving corporation in a merger? In the absence of any agreement to the contrary, X will be an employee of the surviving corporation B. And insofar as the tenure of X, it is as if he has served 10 years in Corporation B and his continued employment under the surviving corporation will be added on to his tenure or to the tenure that he had already obtained while working for Corporation A. Let me point out other options that can happen in lieu of a merger or a consolidation. So in lieu of a merger or a consolidation, corporations can engage in a sale of all or substantially all assets of the corporation. If it engages in a sale of all or substantially all of the assets of the corporation, and as consideration, it will receive shares in the acquiring corporation. This is what is known as a de facto merger. So if I may illustrate, you have Corporation ABC selling all or substantially all of its assets to Corporation XYZ. The consideration that is to be received by ABC are shares in XYZ, thereby making ABC a stockholder of XYZ. This is a de facto merger. In relation further to a sale of all or substantially all of the assets of the corporation, an issue can be raised as to whether or not liabilities that attach to the assets are likewise transferred to the transferee. In the case of Nell versus Pacific Farms, the ruling was that generally, where one corporation sells or otherwise transfers all of its assets to another corporation, the transferee is not liable for the debts and liabilities of the transferor, except in the following situations: where the purchaser expressly or impliedly agrees to assume the liabilities. Second, where the transaction amounts to a consolidation or merger. Third, where the purchasing corporation will be a mere continuation of the selling corporation. And fourth, where the transaction is entered into fraudulently in order to escape liability for debts. So in any of the four instances, a sale of all or substantially all of the assets will come with it a transfer of liability likewise to the transferee. So the transferee now assumes all liabilities that are attached to the assets. This is what is known as the Nell Doctrine. Instead of the sale of all or substantially all of the assets, Another thing that can happen would be there would be a sale of a controlling interest. So when there is a sale of the controlling interest, what will happen is that shares of stock will be sold to another, and that or the purchaser will acquire a controlling interest. So for example, again using ABC and XYZ, so you have ABC, XYZ, instead of selling off all its assets, ABC will sell controlling interest to XYZ, and the reverse will happen. XYZ becomes the controlling stockholder of ABC, which in effect now would allow it to actually deal with the properties or the assets of ABC. So that would be a sale of controlling interest. Note though that the provisions of the Securities Regulation Code insofar as the tender offer rule may be applicable. This option does not require stockholder approval, and neither will there be the exercise of the right of appraisal, because it's a situation where shares are being sold to XYZ for it to eventually control ABC Corporation. Now, the tender offer rule will be applicable depending on the nature of the corporation, whether it is one that is listed or not, or is considered as a public corporation, and the extent of the interest that is being acquired. We will discuss this further in detail at a later date. So those are what you need to know insofar as mergers or consolidation.